All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good afternoon. This is the time set for oral argument in our cause number CV130744, the cities of Apache Junction and Casa Grande versus Doolittle. Council, we are recording today's proceedings, so as you step to the podium, please identify yourself and the client that you represent. Each side will have 20 minutes for argument, and appellant's counsel is responsible for watching the clock and reserving any time for a rebuttal you may desire. Our clocks are not functioning correctly, and you'll start out with 12 minutes, but then our clerk will add 8 minutes, so sorry about that. We're not sure how that happened. Anyway, we've read the briefs, we've conferenced the case prior to argument, and with those preliminaries, Ms. Federhar, you may proceed.
Teresa Dwyer Federhar for the appellants, the cities of Casa Grande and Apache Junction. I have the city attorneys here with me today, as well as council member Evans and other members of the city. In repealing ARS 36-148801, the legislature provided that the repeal was effective retroactively to, from, and after December 31st, 1998. Throughout the litigation below, the county interpreted the "to" in that phrase as used in the retroactivity clause to mean prior to December 31st, making retroactivity infinite and the date meaningless. The trial court viewed it a little bit differently, interpreting the clause to allow the cities to use TIF funding up to that date, thereby, and I'm quoting the trial court here from the summary judgment transcript at page 10, paying off everything incurred up to that date. The repealing act, we don't believe, says that either, allowing for essentially a phase-in of some work, but not all work. The result achieved by the trial court, and why it is wrong, is because it allows and cuts the cities off in the implementation of their plans and their projects before the plan term has expired. Such a result defeats the very purpose stated of the statutory act, the Slum Blight Redevelopment Act. The logical reading of the repealing act was that it was sought to prevent the inclusion of TIF-based repayment provisions in new or amended plans following the December 31st date, allowing those that were in place with plans adopted and in process with set terms to continue and finish. Looking at the words "to," "from," and "after December 31st," we believe that the "to" means back to, meaning you can't have TIF funding in your plan. You can't have a plan with TIF funding starting on December 31st, 1998. And we believe the reason for that date and specifying a date was because, as we all know, the bills become effective if you don't have a date in there or a retroactive date in there like that until a later point in time, and this amendment or this repeal was passed in, I believe, May of 1999 and would have gone into effect in August of 1999, so a 6-month period. And rather than having cities out there with plans rushing in to do certain things before the effective date, it specified a date to go back to when these plans could no longer include TIF funding. Old plans that had TIF funding could progress forward. And I think the statutory language supports that, particularly the introduction to 8801B, because it's talking, the statute itself, the statute at issue that was repealed is entitled essentially increment tax funding and plans, redevelopment plans. And the whole introductory clause of the statute begins, any redevelopment plan may contain a property tax increment provision under which taxes, if any, levied upon, et cetera, talking about the project area, et cetera. As you proceed through the statute, the term plan reappears. The focus of the statute was a plan that allowed for an alternative financing mechanism, and B1 and 2 are essentially the formula for achieving that mechanism. Again, I think the statutory scheme as a whole supports our interpretation, if you look at, I believe it's 1472, the legislature here actually made a finding of necessity in the statute talking about what it was trying to cure here. And it was talking about blights and slums and menaces to the public health, welfare, and safety. And it talked about the fact that normal legislative processes, private development itself, private industry, the police power of the cities wasn't working here. So they had to come up with something different, a different way where these situations existed that it characterized as dire to cure. And
let me ask you a couple of questions about this. And I don't disagree at all with your discussion of the history that went into the initial passage of 361488 and the policy decision the legislature made to have TIF funding. The argument you made about, well, the legislature adopted the language of the repealing statute to avoid the rush to essentially the rush to the courthouse to score by thousands of cities in Arizona. That's an interesting argument, but that's just speculation. What we have to do is look at the language of these statutes. So we have the initial statute and the repealing statute. And this, let me come to the repealing statute. That statute repealed 148801, the entire provision. At the same time, it also included changes to other statutes that involved use of public funding, one for, I think, stadium districts, and the other for, let me think now. Stadium district was one, and then the other one was for, forgive me.
Parks.
Theme parks, right, theme parks. And there what this legislature did is it did repeal those funding mechanisms, but it allowed for some additional lag time. So they were repealed, but if the cities had taken specific steps or the districts had taken specific steps on or before a particular date, the projects could go forward and the cities could have and use the funding. The legislature didn't do that with this particular repeal. Instead, it made this repeal effective to, from,
and after.
and after. Thank you. To, from. I mean, it's pretty clear what to, from, and after. So it seems like that is very significant, at least in my view, because if the cities had wanted to allow for a continuation of funding, if the legislature had wanted to allow for a continuation of funding for those plans that had been adopted before the cutoff date, they could have utilized that type of approach that they used for theme parks and then the stadium districts, and they didn't do that, and I find that very telling.
And I believe that at the end of the day, the legislative history showed that they coupled a bunch of things together in one sort of bill. So maybe their focus wasn't exactly on the redevelopment districts, but I would say to you, the two has to mean something here. And it doesn't mean it's infinitely retroactive, because then you wouldn't need a date. And we've given you samples, I believe, attached to the brief of you can say retroactive forever. It means it's to start on a certain date.
Yeah, if that's your strongest argument, I mean, there are, I think, other reasons, because I think it's pretty speculative, but there are other reasons the legislature might have decided to make it to, from, and after. For example, it may have decided that because property taxes are based on valuations taken the year before, it wanted to have a more contemporaneous cutoff so that it was dealing with the year before, so that it would just start it earlier and avoid later problems. So it would be consistent with property tax valuation schemes. So there are other, I think a person could come up with other reasonable grounds for the legislature to go to, from, and after.
But it doesn't necessarily mean that retroactive meant plans in place that were moving forward, or the integral part of the plan that had been adopted with TIF provisions were intended to eliminate those TIF provisions. They don't read to as that. And maybe there is more legislative history on these other provisions, but there certainly isn't legislative history indicating that they intended to stop cities with plans in place with TIF funding that was ongoing.
Well,
from
the fact
finishing.
sheet begins with, I believe, a statement that this is designed to stop the access of public funds. I mean, it's a pretty blunt statement right at the beginning of the final fact sheet about
And
the
following
repealing.
up on that, it links the theme parks and the multipurpose district, saying, this is the Senate fact sheet, the stated purpose of the repealing act is to limit access to public monies for the purpose of financing theme parks, multipurpose facility districts, and redevelopment plans, which seems to support the suggestion Judge Norris was raising, that the legislature carved out the ability of those other entities to continue on, but not with the redevelopment plans.
Well, it doesn't identify exactly what the funding is they're talking about. I understand it was eliminating plans moving forward with TIF funding. Certainly, there was going to be continued access to all sorts of public funding. It didn't repeal the eminent domain statutes, for example, in the act. And the question really did it mean to repeal TIF funding for plans in place with ongoing TIF funding? And what Judge Brain said, well, anything past this particular date and allowed this phase-in. And I don't read the statute that way either. But in any case, even if the repeal is read the way Judge Brain read it, we have statutes that say you can't repeal accrued rights. And we have argued that in this case, to adopt a plan that anticipates a certain term with certain funding being there is in fact an accrued right. And we've cited you some cases. I actually think the Kenton case out of Ohio is a better case. There's a recent case following up on that, Toledo, which I can offer as a supplement after argument. But it talks about the fact that we're not talking vested rights as the appellees talk about in their brief. We're talking an accrued right under 1249 and what that means. And here cities relied on the fact that TIF funding was going to be there, in fact, and available to them if they passed these plans and set a term. And in fact followed in phases, as was some of the testimony in deposition.
Arizona case law on what is an accrued right, I think to say is a little mushy. That's a legal term. I'm sure it's in Black's Law Dictionary somewhere. How would you define what is an accrued right?
A right to money. I would certainly say in this case, and that's why the Kenton cases or the Ohio cases are similar. Here there was a formula by which they would get money. And it's not that they were looking for the power or the authority, because legislatures can repeal your power, but here there was a promise of actual money, an actual mechanism with a formula for obtaining
Let
money.
me ask you about that. In reading the Arizona accrued rights cases, and I do think, and I mean this respectfully, I think it is a bit of a mushy area. It's a little murky, but in looking at and closely examining the context and the facts of all the cases, it appeared to me, at least, that one way to describe an accrued right is a right that, for lack of a dog chasing a tail, it's a right that is ripe for enforcement. It's not contingent. It's not executory. It exists. Here my concern is this. When I look at the original statute, this whole TIF financing is based on an assumption property values are going to increase. Well, property value, that's a big assumption. There's no guarantee, there's no lock that property values are going to increase. So that seems to me to make, even if I agree you had a right to something, or the cities had a right to something, that's an expectant right. And then furthermore, the county treasurer has to collect the funds from the property owners, the taxpayers in the districts. That too is something that is not locked in. That is subject to the future uncertainties. So then, how then is this right one that's ripe for enforcement when we have these fundamental uncertainties in this whole type of structure of financing?
Well, I believe it is not as mushy or as unripe as this court would have it, not based on...
It only may be me, so that's they're smarter than I am. So it's just me.
Certainly based on the facts of this case, because the facts of this case shows for 12 years there was funding that was available and went through. And the treasurer only in 2010 decided to reverse her position. So even in terms of reading the two, everyone was reading it the same way for 12 years, number one. Number two, I think what the statute says is if this redevelopment is occurring and property values go up, and that was what was happening, redevelopment was occurring pursuant to these plans, and in fact, property values were going up, and the TIF funding was flowing. And it may not flow exactly because of when taxing occurs and when assessments occur at different times of years. It might not be this perfect linear flow, but it flows through, which is, of course, why the city was advancing or obligating funds and paying as it went here, so that it would not wind up in a situation like Corbin, for example. Well, Corbin is not even analogous in our view because this didn't involve any bonds. But I think that was concrete enough for purposes of this case, that there is a formula that says you will get money if these events happen, and based on that, redevelopment to some level will cause property value to go up. And the city will have to make decisions based on that and budget accordingly in terms of whether it needs other funding sources to complement if there are enough TIF funds this year. This case shows there were. The new Ohio case that I was talking about was a formula based on students, the student population in the schools, and if I could find it for you, I would, but it's the Toledo High School District. And in that case, there were school districts, and there was a formula based on your student population that year that you would get a certain amount of money. And it was determined that that was an accrued right, so that when they repealed that statute, the schools that were following that formula and done other things under the statute were allowed to continue to get that money. I see I have about 5 minutes, I think, left.
Actually, I think you have
Is that
more.
the correct?
Is
Yeah,
that
that's it.
So I'm going to reserve the rest of my time for rebuttal.
Thank you. Mr. Walsh.
Good afternoon, Your Honors. Jeffrey Walsh of Greenberg Traurig. I'm honored to represent the Pinal County Treasurer, Dolores J. Doolittle, in this appeal. There are 3 points I thought would be worth making this afternoon, and of course, answering any questions any of you may have. The first one is one that I think, Judge Norris, you've already started asking some questions about, and that is that the legislative intent to repeal the city's authority to receive or use TIF funding for redevelopment is manifest from its decision to repeal the entirety of the TIF statute, as well as the language in the statute that was appealed. The second issue, time permitting, would be that the cities could not have acquired an accrued or vested right in the TIF funds as they were accessing them improperly, not as permitted by statute. And the third is that even if the cities were accessing them properly, they could never have acquired an accrued or vested right because municipalities don't accrue rights to political power as against the state. If I can move to the first one, the legislative intent on repeal, Ms. Federher went through some of this. The legislature in 1999 amended ARS 36-1481 to remove TIF funding as a source of repayment for bonds. The right to issue bonds still existed, consistent with constitutional law. The legislature then went further and repealed 1488.01 in its entirety, and that's what we believe is very significant here, including Section B. Now, Section B really has 3 parts. It has a preamble, which gave the municipalities the authority to include TIF funding in the redevelopment plans, and this is what the cities are trying to focus on, is they're saying that's all that was repealed prospectively. But the legislature also eliminated the municipal power formerly found in subsection B2 to have the county allocate and pay into a municipal special fund, the TIF funds, to defray principal, interest, principal and interest accrued on loans, advances to, or indebtedness incurred by the municipality for redevelopment. The city's argument is in essence that the legislature only repealed a portion of 1488.01 and left in the preamble in B that would allow them to continue receiving TIF funds and using them if they had a redevelopment plan in place previously. But B2, when that was repealed, eliminated the right of those municipalities to use TIF funds to defray principal and interest on loans, advances, et cetera. Your Honor has already cited, Judge Norris, you cited to the legislative history. I'll cite you to another portion of that same Senate fact sheet a little bit lower down that says the legislature was motivated to repeal the statute, at least in part, by the ruling of Division 2 of this court in the Corbin case. And the Corbin case, of course, held that portions of the TIF funding scheme were unconstitutional in the words of the Senate fact sheet. I think the Corbin case went further, but that's what the Senate fact sheet said. So that was apparently one of the things that was on the legislature's mind in repealing it. And the point here is, rather than amending 1488.01, either to allow TIF funding to continue if redevelopment plans were already in place, or adding some language that would cure it by requiring that municipalities, comply with Article 7, Section 13 in engaging in bonding, the legislature instead decided to repeal the whole kit and caboodle. So our view is there are no more TIF funds to even be talking about here in this courtroom. All we have are ad valorem property taxes, which existed before there were TIF funds and after there were TIF funds, but this concept of TIF funds was completely eliminated by the repeal of that statute. So that was my first point. The second point is the cities could not have acquired an accrued or vested right in the TIF funds because they were accessing them improperly and not as permitted by the statute. Now,
they disavowed any claim of vested rights, but talk to us about the topic Judge Norris raised. What is the definition of an accrued right under Arizona law?
Well, I view an accrued right as a right that has ripened, that is not subject to any contingency, that a party has an absolute right to receive without further action on their part or further events. The cities rely, of course, on ARS 1-249, where this accrued right provision comes up, and the statute says there, no right accrued is affected by a repealing act. The question that we raise is, when, if ever, did the cities accrue a right to receive future TIF funds? We need to look at the language of the now repealed statute to see how and when those rights were created and how they could be exercised, because access to the TIF funds is a creature of the statute and may only be accessed in accordance with the statute. The cities argue that they have a right to TIF funds simply by creating a redevelopment district and citing that they're going to use TIF funds in there. But the statute requires more. Subsection B2 provides, first, that the portion of the levied taxes each year in excess of the amount shall be allocated, and when collected, shall be paid into a special fund of the municipality to pay the principal of and interest on loans, monies advanced to, or any indebtedness incurred by the municipality to finance or refinance in whole or part the redevelopment project. So what the legislature was looking at is the city must incur an indebtedness in connection with its redevelopment plans for which it has identified TIF funding as one or several sources of recovery.
So it can't pay as it goes?
That's my point, Judge, is that the cities have admitted repeatedly that they were paying as they go. Once they know they have $250,000 perhaps in TIF funds coming, they get the next stretch of road or sidewalk or whatever done. But that's not what the legislature was looking for here. The whole TIF scheme was to enhance the ability of cities to get redevelopment work done more quickly by providing a source of revenue that could be used as security to go issue bonds or make special assessments, even make contracts, but make contracts that were contingent on the TIF funding. The cities have said they were doing something else entirely. Now, was it lawful or not? In our view, it was not lawful, but that's beside the point for this appeal. The point is that they couldn't accrue a right in something that the statute didn't permit them to do in the first place, which is to go on this pay-as-you-go basis.
The language of B2 would probably make an English teacher blush. And it is not I think it's fair to say it is not a paradigm of grammatical clarity with its use of commas and fragments and so forth. But I think that there is a principled way to read that. And I could parse it through for you, but I think the city has done that in its briefing. Or excuse me, the cities have done that in their briefing. That it would allow, under the monies advanced to redevelopment projects, that it could allow for pay-as-you-go. So, but bear with me. Let's assume the cities are correct in their construction of that portion of the statute, that it does allow them to pay as they go. Then, do you not have an argument on accrued rights?
Yes,
that?
we do have another argument on accrued rights, assuming that you're correct about the reading of the statute. In City of Tucson versus Whiteco Metrocom, this court held that municipalities do not have vested rights in their municipal powers. Political powers conferred by the state upon municipalities do not create vested rights as against the state, and the legislature has the absolute power to change, modify, or destroy them. We're talking about a function of political power here that the state has delegated to the municipalities, which is the right to declare a redevelopment district, to use the powers of eminent domain to seize blighted property, to remediate that using bonds or other funds, and then we have this increment of TIF funding. It's a political power delegation that belonged with the state, was given to the municipalities for a period of time, and could be freely taken away. So if you believe, as we do, that when this court was talking in the Whiteco case about vested rights, that they were also talking about accrued rights, because I can't see how a vested right would not also be an accrued right, then this court has said that a municipality doesn't have the right to rely on any particular taxing and spending scheme by the state or that was delegated to the municipalities. Now, the Whiteco court did not make new law when it ruled, and I said this court, it was Division 2, and I apologize.
They don't count. No, they don't.
They do when you stand where I am, Your Honor.
But they do, okay.
The Whiteco court didn't make new law. That court cited to a couple of Supreme Court decisions. One of them was Board of Control versus Buckstege, which is a 1916 case. The other one I've forgotten the name of, but it's cited there in Whiteco, and I think it's a 1927 case, both of which declared that the legislature has unlimited authority over and ability to curtail the powers of a municipality. Now, Ms. Federhart cited to the Ohio decision in the Kenton School District case, and that's clearly in opposite to what I'm saying here. So Ohio law is clearly in opposite to what our Supreme Court has said. But going back to my second point, which is what does it take to get an accrued right, there's an important distinction between the Kenton School District case and this case anyway. In Kenton School District, Ohio had a statute that said if two school districts consolidate, they get the same funding that the two of them would have gotten separately for the next 3 years. So they're not penalized for doing the smart thing, which is consolidating and saving money. Notwithstanding that, after these two school districts consolidated, in the second or third year, the legislature changed the law and no longer was going to provide that double funding, if you will, to the consolidated district. That's how the case went to the Ohio Supreme Court, and the Ohio Supreme Court said that the school districts had relied, basically detrimentally relied upon the statute as it existed to make their decision to consolidate. The consolidation is irreversible. The money's been spent. It would take a lot of money to deconsolidate. They had, in essence, removed all contingencies possible to their right to receive the funds that the legislature had guaranteed them. Excuse me, we are far away from that here. The cities have not shown that they have done anything in reliance on this funding such that it would become an accrued right or a vested right. All they have done is drawn up plans, which we described in the trial court as a wish list, that excuse me, that they hope to accomplish at some point in time in the future over the 30 years of the plan, revenue willing and available. So they've made no legal commitment to anyone. Those plans can be changed, extended, modified. They were in fact modified. The scope of the district, the redevelopment district, could have been adjusted. They could have amended the plan to make it last 40 or 50 years. They could have decided to do more or less work or different kind of work.
Forgive me, I thought the record, the cities presented evidence that during the 10 years after the date of the repeal, or the effective date of the repeal, that the treasurer had in fact distributed TIF funds, and the cities had used them to pay as they go, so to speak, on various projects within their respective 3 districts.
They did, Your Honor. That's
So,
correct.
I'm
But what
sorry,
I'm
I'm not tracking your argument then.
Well, I guess my argument is this. The formulation of an entire plan didn't create an entitlement to get all of the money necessary to receive that plan.
Okay.
Nobody was guaranteeing the district or either of these cities that there would be enough TIF funds to build out that entire plan. If they got enough money in year 2005 to do the first mile of a 3-mile road improvement project, then they got that much. But nobody knows whether property values would ever support doing the next 2 miles. So they have a plan that they'd like to implement. That doesn't mean they've changed their position in reliance in any way. And it seems to me that as a minimum would be a requirement for an accrued right, is not simply that there had been a statute in effect at the time that caused a redevelopment plan to be put down on paper as a wish list, but that some action be taken in furtherance of it. So I did want to talk about the reason why the treasurer is here. Under the statutory authority in ARS 11, the treasurer is prohibited from remitting funds to any person or entity that is not entitled to receive them. And that's how we ended up in court here. Things had been going along in Pinal County in the treasurer's office for a number of years because the tax information and a formula to calculate the TIF funds was already part of the software. And every year, the TIF funds would get calculated and a report would spit out saying this money goes to the city. At the time, Ms. Doolittle, at the time that this all came about in 1999, Ms. Doolittle was a deputy treasurer but was not responsible for that particular decision or that software. She became the treasurer in 2004 when Treasurer Turnbull retired, and she discovered just by being diligent that, wait a minute, I don't understand why some property tax money is going to the cities differently than what I understand the law to be. And she looked into it, consulted with the county attorney, talked to the deputy treasurer who was responsible for running the software, and found out the thing was kind of on autopilot and that there really was only a repealed law behind it. And that's what led us here, is we had a very diligent treasurer who wanted to make sure that she's doing right and that the money is going where it should go. She obviously has no personal interest in how this turns out either way, as long as the court tells us. I did want to talk just briefly, I guess I've got 4 minutes left here, if I'm reading the clock correctly, about the constitutional question. The Corbin Court spoke, of course, in very broad language and struck down the statute that we're talking about altogether, or that's how we read it. The court said we are constrained to hold that the provisions of our slum clearance and redevelopment law, which authorize tax increment financing in its current form, are unconstitutional as violative of Article 7, Section 13. We know that Corbin dealt with bonded indebtedness, and Article 7, Section 13 speaks of bonded indebtedness, but it also speaks of special assessments. And something that was never briefed to the trial court, but I think is inherent in the trial court's ruling, is the court didn't consider this TIF funding scheme to be a special assessment or a bond. There's no doubt it wasn't a bond in the conventional sense of municipal bonding. There are no third-party investors. But there's a serious question here, whether this court resolves it or the trial court does, whether this is a special assessment because it is money taken from a particular group of properties, in this case the properties inside the redevelopment district, and spent for a particular purpose rather than for the purpose of the general public, that is back to the benefit of the redevelopment district. And we've looked at some of the special assessment law, but we haven't briefed it, and I don't mean to suggest to the court that we have. But it seems to me that when Corbin was speaking very broadly after it talked about bonds, and it kept saying the fundamental problem here is that ad valorem taxes are being used for a particular purpose without a vote of the electors, that the Corbin court may have been thinking a little more broadly than it was writing about, because they seem to have said rather clearly, this statute's unconstitutional, not that it's unconstitutional as applied to bonds.
I ask you under what analytic framework we need to resolve that issue?
I'm not sure I understand.
Why do we need to get to this issue?
You
you're now
don't,
discussing?
obviously, if you decide it on other grounds in my client's favor. The constitutional question should be the last one, obviously, if you can decide it on any other ground. But
if that hasn't been briefed, and wouldn't that have the effect of saying that TIF funding wasn't permissible either before or after the repeal, which is a much broader decision than the trial court reached?
the trial court didn't need to reach the decision about the before, because the treasurer is not seeking recovery of any funds before 2010. She may not have the authority to do that.
But
She's just simply saying, going forward, my job is to make sure it gets paid correctly. So the trial court wasn't really tasked with the question of, well, what happens to the money that was given out in 2005 or, 1997? That is
struggling with the notion that even under your contingent scenario, we could reach and resolve that issue based on how it was litigated below and what's properly before us.
I think the question that I might be asking you to resolve is a little narrower, which is that the Corbin decision, or whatever decision this court would issue, if you have a different rationale than Corbin, is that not only is bonded TIF funding unconstitutional, but because any use of the TIF funding statute would be a special assessment, that would also run afoul. Now, I don't think this has application to any parties other than these two cities. I mean, nobody's come forward and said, well, we're in the same situation here. I mean, we know Tucson was at one point in time. But I think that the Corbin court was speaking more broadly when it just, invalidated the statute as a whole rather than as applied to bonding. So
Then why did the legislature go to the trouble of attempting to repeal or repealing the entire TIF statute if it was already unconstitutional?
I guess I can't answer that because I didn't know what was in their minds at the time. Maybe somebody was just trying to clean things up. Yeah. I also don't understand why the cities didn't take a big hint from that they shouldn't continue asking for TIF funding, and I don't know why Treasurer Turnbull thought it was still proper to give them the money. These are things that are lost to history, I'm afraid. Mm-hmm. Can I answer any other questions for you?
No, thank you. Uh-oh.
Sorry.
That's right.
Number one, the judge below, Judge Brain, found that the city's use of the funds was constitutional and appropriate. No cross appeal has occurred here or even cross issues, and we've briefed that. And there's no special assessment going on here. These are existing taxes, property taxes, and you're just looking at an incremental difference if they go up. So there's no new tax or no new assessment going on. But I'd like to, the Toledo case that I was referring to is Toledo versus State Board of Education, 18 Northeast 3rd, 505, and we will supplement with that authority, where there was a formula approach to certain school districts if they based on their numbers. So again, what I believe is accrued right is a right to money. We're not talking about a municipal power here. We're talking about the municipality has put into place a plan and it has begun that plan through phased development, and it has had its funding, significant funding mechanism pulled from that. And there are real obligations here. You could look no further than, it's in the record at 149 Exhibit A, the deposition of the assistant city manager for the city of Casa Grande, who talked about once the county had stopped the funding and was supposedly holding it, the fact that they had to rejumble obligations with specifically the Downtown Street Project Phase 2, because there was no money to pay for that. And as a result, they had to go use excise taxes, have an excise tax passed in order to generate the revenue. It seems to me that if we read the retroactivity clause in the accrued rights statute, the way the trial court did or the way opposing counsel wants to, you have a problem because these cities have started plans to cure a problem. And the statutes all the way throughout recognize that that's going to be a long-term continuous process. There's even places in the statute where it talks about that over time. So if you start redeveloping a certain section of town and you get the one building built for your new civic center, but you run out of funding, the significant funds that were funding that, because you can't change the street structure around it, or you can't put in the utilities necessary. You've just added to the blight you were trying to decrease. And I think that's the only logical reading of the repeal is to allow those cities that had term-limited plans that they were pursuing and were in effect and were doing things on to move forward with TIF funding. It's limited for a certain amount of time. A redevelopment plan under the statutory 1471-16 is the definition of a redevelopment plan, and it makes it clear it is not a preliminary or tentative plan. It is a very real thing. If you look at 1474, which lists the municipal powers, subsection A4, it allows the city to invest redevelopment project funds in reserves because it understands that there may be times when it's not ready for immediate disbursement because you're paying at the end. You've contracted with the contractor to build the building, they get paid at the end, and that payment goes through then. So there are real consequences to these cities when you say you cannot finish your plan. They're left with half, 1/4. I mean, these were passed in 96 and later 98. And they can't just amend them to go on forever. The statute also says if you don't do anything for 10 years, you're automatically done. So it forces cities to actually do things. And it expects a specific term, a term limit. I think these cities reasonably relied on the monies. They put plans in places. They began development. And without those funds, they certainly can go try to pass bonds or try to do other things. But the real significant funding mechanism that would help improve this blight, because nothing was changing, it has now been eliminated for them, and they're cut off midstream. And that, I think, is an accrued right, as well as, I think, a reasonable interpretation of the retroactivity statute. Certainly, it's the interpretation that the treasurer had for a number of years, both treasurers in this case. There was some discussion of a clerical or computer error below, and that record, it's in the record in terms of the argument. They were well aware, both treasurers, that this money was getting paid and continue to pay it. We'd ask you to reverse and remand for further proceedings. Thank you.
Thank you. Thank you both for your arguments, which were very helpful. We will take this matter under advisement and issue a ruling in due course. At this time, the court stands adjourned. Thank you.